The new H-1B rule is our discussion today from Shihab Burke. I'm Attorney Sam Shihab, and with me,
Brian Burke.
We're having an exciting week here, Brian, in the office. We're doing remodeling. I can see my office behind me is not much on the shelves. We are ripping the carpet, painting the walls, and reconfiguring the office. We figure at the end of the year is a good way, but we're not here to talk about that. We're here to talk about the new H-1B rules that got finalized, and it's 150-page regulations, and there's a lot there to discuss. And we're not going to talk about all of it, Brian. We're going to talk about highlights of it. We're going to pick and choose things that we think is relevant to our listeners.
Yeah.
Just to let everybody know, we are immigration attorneys. We practice immigration law throughout the U.S. We focus on employment immigration law, and we focus on family immigration law. We have been doing this for 3 decades, we are just focused on this is what we do. We're immigration lawyers, and we spend an hour every Monday at 6 o'clock to discuss things of your interest and then answer your questions. I see some questions coming in already. Please bring them in because we're going to do our best to get to as many of them as we can, if not all of them. And without further delay, H-1B new rules, modernization, Brian. This is about making it more in touch with today, not yesterday.
Yep.
And they've done a few good things. Let's go through them as they are, we feel relevant to people talking to us today. On this 1 hour.
No, it's funny, just during our session last week, somebody had in the comments saying, hey, these things are in executive review. And my thought was, well, we'll see if we get them. And literally 24 hours later, last Tuesday, well, we got them. So at any rate, they're here. I figure we have maybe 5 or 6 things we thought were the ones people were most interested in. And first thing on the list is specialty occupation.
How about we start with the effective date?
Okay. All right. We're going to go from the beginning. Effective date is, let's see, January 17th, 2025, just before the new administration takes control. So they got their rules in at the very last second. Good upon them. Why? Yes, exactly. So if you're trying to get an H-1B in under the old rules, if you think they favor you much more, you have precious little time to do it. Premium processing case, 15 business days. So there you go. There's that.
Date of filing or date of review?
I'm sorry. Whether they'll judge you by the date? Yeah, I don't know.
I don't think we're gonna fight over this unless there's a significant difference.
Yeah, sounds like a good court case is the bottom line.
The change. I think if you want to put a label on it, positive or negative, Brian.
All
right. As you think about it, I'll answer my own question.
I have my positive. Go ahead.
Okay.
Positive.
Yeah, positive. Positive. Neutral to positive. I like a few things about it. I don't like a few things about it. So let's go through them in the order that Joe gave it to us. How about that?
Yeah. So we're gonna hit the big bullet points here then. So what does a specialty occupation mean? Is changed? Well, has it changed? Is the question, because what they say about their before we even talk about what the substance of the change is they say DHS does not expect that there will be an increase in RFEs or NOIDs as a result of codifying existing USCIS practices. And I guess what that means to me is, if you have a degree that I, in my estimation, think is related to the H-1B, you're going to be fine. If you don't, or you can't get there through an evaluation, a credential evaluation, something like that, you're going to have a really serious problem. But let's see what they say. So they say that your degree must be, quote unquote, directly related to the occupation, which means there's a logical connection between the degree and the duties of the position. So they're looking beyond, they're looking beyond the title of your degree to what you did for that degree and looking to the duties of the position, how do they line up? So
Isn't that
basically,
what they do already, Brian?
yeah, I mean, kind of. I mean, if I wanted to argue that somebody's say engineering degree is related to their H-1B specialty occupation in the software realm, I'd say let's highlight all the computer coursework that they had that's related to that occupation, for example.
So one word that got a lot of attention is the word directly related.
Yeah.
It was before related, now directly related, but I think they mean the same thing.
Yeah.
I don't see a difference. I think they have emphasized. I think they kind of walked down the path, and there was a lot of criticism on what was the original directly related, because the feeling was that if you are, for example, an electrical engineer, you may have difficulty getting a job doing low voltage, like in car manufacturing, because it may not be electrical engineering. You know, a little bit different. So there was fear that the field is going to be narrow. There has been a lot of criticism in the past that what USCIS original language, proposed language, which came from the Trump administration, by the way.
Yeah, a lot of
the Biden administration, that had a requirement that is significantly narrower than the actual practice in the U.S. Yeah. And then they walked that back out again to where we at. Yeah. So they think they have a new specialty occupation definition, but they seem to have the same.
Well, they say we don't expect no changes if you're getting cases approved right now, and that's the thing. Like, I heard from a lot of people say, "Ooh, with my degree, am I still going to be able to get H-1B approval?" And my response to them was, "Well, if you've been working in the degree field for a while, you could probably get, you know, an equivalency evaluation based upon your experience." But, you know, I think you should still be able to argue those tough cases, essentially, that electronics engineer, for example.
Especially in light of the deference standard. That is not on the list, but we can talk about it. The deference standard. So, and that's also what the Biden administration and the Obama administration and prior administration has done for years, and was scrubbed by the old Trump administration, reinstated by the Biden administration. So there has been a period of time in which it didn't exist, which is, if as an agency, if USCIS approves this case, and then you have a subsequent case like an amendment or an extension where it pretty much is the same parameters, they're going to give deference. Yeah. They are going to not reopen everything one more time. Yeah. They're going to just approve it, because
if we found you were in a specialty occupation last time, we're going to believe you're in a specialty occupation this time, as long as the facts, you know, are essentially the same. Yeah.
Yes. Yeah. And that makes a lot of sense, because it has to do with
efficiency,
administrative efficiency.
Yeah, that's where my brain goes immediately. You don't want USCIS to move any slower. You don't want them forced to be, you know, oh, we approved everything for this guy last time. Now you must re-adjudicate every aspect of their case.
Which is a nightmare if you have to do that every time, in terms of how long it takes to review a case. Yeah. And issue RFE that you issued it and you had expert analysis before and you submitted all that and they convinced them that this is correct. And now you got to redo this one more time. It's a nightmare.
No, yeah,
so,
painful. Yeah.
So with that, specialty occupation, if you were in a specialty occupation before, you will be in a specialty occupation in the future. It shouldn't be a problem. Okay, sounds good. So that's check mark that one, Brian.
Yeah.
When an amendment is needed.
Oh yeah. So when is an amendment needed? Well, one thing we know for sure is that the Simio policy that says, hey, a change in work location will require a new LCA. Well, that's codified now, which I kind of like, because I'm an order sort of person, and I really hate that, you know, if somebody wanted to learn H-1B visas fresh and new from the beginning, that, you know, they'd have to know, oh, but you have to know that there's about 30 different policy memorandums on the subject. It's good for the law. If only they could fix that in the perm scenario, Sam. But yeah.
So what do you think? What do you think about other amendments, like change in salary, for example?
I'd say the material, as far as I know, the material change standard, you know, stays, you know.
So no change.
Yes.
All right, I'll
Yeah.
take it. So that's no change. That's basically paperwork.
Yeah.
It was in the semio policy by an AAO decision,
Yeah.
and now it
Oh, it
is.
wasn't even an AAO decision. It was no. It was adopted AAO decision. I recall. Yeah.
Um, all right, sounds good. Employee-employer relationship, Ryan.
Yeah. So it's the old bona fide. Well, maybe you're thinking about a different thing, but we'll see. Well, there's one aspect of the employer-employee relationship, but it's one part of the specialty occupation that they skipped over. So I want to talk about both of them. So employer-employee relationship, there's a general requirement, and I don't think many people are running afoul of this, is that basically a U.S. employer must have a legal presence in the United States, but nothing requiring. So that's really kind of it. Basically, you must be a legally formed business if you're going to employ somebody in an H-1B
Well,
occupation.
you have to be established in the U.S. I don't think that
Yeah.
was clear before. So companies that are set up in, let's say, in India, they can file an H-1B petition without having an office here, without having a presence here, and that is now gone. No longer,
Yeah.
you know. So yes, and then the one that I like a lot is the beneficiary owner H-1B.
And you want to talk about that? You want to talk about this one a lot, so let's have
Well,
it.
this is a big one. This
It's a common question, that's for sure. Yeah.
Well, to me, this is big. Let me tell you why. Number one, this was done prior to this H-1B codification, and you could file a owner who owns more than 50% or 100% of the company can file an H-1B under certain conditions before.
Sure.
All you have to do is separate the hire and fire decision from yourself as an owner. You lose control. You give up. You surrender that right, which is inherent in ownership. When you surrender that right,
employee relationship. Yeah.
and you give it to someone else. Typically, it's an outside board. Then that outside board can hire you, the owner, to do H-1B work. Now, this was hit and miss. Not only is it hit and miss, when you go tell somebody, hey, I can do an H-1B for you as an owner, it's not codified. You really are.
You're off the trail, off the tracks.
Yeah.
You are in a weird scenario where if you can present that to the government and all you got to do is catch a dumb officer or a mean officer, and your case is up in smoke.
Toast, and your client is toast, and the money, because it's not cheap to set up to make this entire system.
Yeah. It's not an easy scenario. That's for sure. It's not a practical solution for most people. We'll just set up a business with an outside board, and you'll be
So now it has become codified, and because of that, a lot of people with a lot of money abroad now don't have to create an L1A job, because you have to have an employer, you have to have a presence. Now you can do an H-1B for yourself and open a business in the U.S.
Yeah, I mean, one of the big challenges of L1 visas are going to be a great solution to bring over to open new branches of businesses, of course.
Yes,
but sometimes they don't work. You have to have a business abroad. You have to leave that business abroad, and
employed abroad for 1 year.
Yeah.
You cannot leave that business. That has to be operating. You cannot sell that business. Has to be continuing. It has to be the existing business abroad all along.
Yeah.
Now you don't have to do any of that.
I get why. Yeah, I like it. It's exciting. You can really kind of, in theory, if with a well-structured H-1B visa, pick up and move to the United States, and having never started a business before, if you just got a silly amount of money and want to open a business in the United States,
Or you can pick up your company and bring it here.
Yeah.
You don't have to keep it abroad because the L visa requires you to keep it abroad and keep it going.
Yeah. Yeah.
So that's a lot of exciting stuff right there. Yeah. And that's why and by codifying it, and also, by the way, it gives you longer time than opening an office. So when you open an office under L1A, you get 1 year.
Yeah.
H1B, owner, beneficiary, H1B, 18 months.
Yeah.
You get 18 months, and then you get 3 years after that.
Yeah.
And if you do that, then you could potentially file for a green card for yourself.
Okay. Well, I do want to clarify something though. Still, the majority of your time must be spent on H-1B specialty occupation duties.
51%.
51%. 50.00001%.
Well, the majority of time is 51% or 51.005, but I just want to convey to our listeners,
more than 50%
it
of your
is not
time.
80% of the time.
Yeah, yeah.
Majority in the legal sense is 50% plus
Anything, yeah.
a rice,
Yeah,
right?
exactly. Yeah.
When you're weighing it.
Yeah.
So as long as you're doing that and you have to document it, then you can do an H-1B for yourself. You can
Yeah.
do that on your own. You can, if you have an entrepreneurial spirit, you can do that while you're here on the U.S. for an H-1B for a while. You can go and go on your own H-1B. Now, there's going to be, this is a beginning of a path. This is now the path has been defined, but the breadth of that path and the depth of that path is yet to be defined.
Yeah. I mean, go ahead. I'm sorry. Finish your thought.
No, that's it.
I can imagine how this. I can imagine this case right now. I can say, okay, we're gonna make sure one of the things is they're gonna want to see a job duties with a percentage breakdown, right? So you give them a percentage breakdown showing, here I'm spending, 51% of my time, on technical stuff. If you're a software person, I'm the CEO, I'm the heads, but I'm, technically 51% of my time is devoted to technology operations, specialty occupation. You're good. Now, an interesting thing is now the changes to the site visit program. So you send that off to USCIS, you say 51% of my time and is going to be spent on specialty occupation duties. But the site visit program changes such that it might impact how, I guess the point I'm making here is the site visit program from USCIS is now, compulsory. You must be a member of. I would expect that on that site that for a case like that there's a greater chance that they're going to be out there coming to say hello to make sure you're not just CEOing around the office and not doing your technical duties. No.
Well, before I address that, I want
Yeah.
to take a step back and talk about the site visit being mandatory,
Yeah.
because that would be the only thing that I think is incredibly negative about this. Because let's face it, the site visit program suck. The people are not well trained.
Okay, I'll give you
Some
that.
of these officers overreach,
Yeah.
abuse, and
Right.
also there is not a clarity. A lot. I mean, there's going to be a lot of fraud. A lot of people pretending to be USCIS officers, taking advantage of simple immigrants who do not know what's going on. So
Yeah.
there has to be an improvement of the process, and also there have to be better training.
Yeah.
Some of those guys are amazing. Some of them are pathetic.
Oh yeah, and it's a little bit.
Let's face it.
It's
Yeah.
a little bit scarier now. That same note is, now it's basically you must give them access to the work site. And if the work site's your home, I guess you're going to have a USCIS officer sitting on your couch.
Yeah. So there has to be an 800 number, the USCIS 800 number, where people comes in and say, "I'm doing a site visitation. Here's the case number, and here's my badge," and people can call this 800 number and confirm it.
Well,
That this case number exists and that badge of that person name and detail exists. So you have some kind of a comfort level, right?
sure. I guess our view on the H-1B, site visit program it was never really optional. Technically it was not. It was optional. You don't have to comply, but I would talk to to our employer clients and say, well, you have two options. You can give them the information, or you can get a very, very, very painful notice of intent to revoke. Sort of scenario.
But here's where I'm really concerned about this, Brian, is
Sure.
that we are moving towards a system in the world that a lot of people are working remotely from home,
Hmm.
and the work site is at home.
Yep.
And now you have somebody that can knock at your door and walk inside your house
Yep. Yep.
without a warrant, without now they are inside your home,
Hmm.
right? You
Yeah.
do not know that as a beneficiary when the employer listed your home as the work site. You didn't sign on that. You didn't authorize the right for that person to invade your home,
That's a very good
right?
point.
The government to invade your home.
Yeah.
You didn't approve that. Now your livelihood and your employment depends on the government being in your living room, and that is a problem. I have a huge problem. I have.
Well, I do have a slight. One of the things on that list related to the site visit program is they do allow you to have an attorney present or a representative from your employer So that's nice. If you're an attorney anyway, one of the things. Let's talk
But
about
there's no notice in this site visitation.
Yeah. Well, here's the notice right here. Well, I want my attorney present. Uh, it's not if it's. Again, I'm gonna have to
The
read.
attorney has to be called. And also there's no hours of operations. They can
Yeah.
knock to go till 10 o'clock at night.
Yeah.
They
Yeah.
can come in 2 o'clock in the morning.
Yeah.
Can they?
I mean, I wouldn't put you there. You're working. Is it actually, Sam? Is it a work site if you're working at 2 o'clock in the if you don't work at 2 o'clock in the morning? I guess it's a work site all the time. I guess if you're on call, you can come at
A
two
lot of
o'clock in
people
the
running
morning.
2 or 3 shifts, and he's working at home in his pajamas, supporting a software that he's monitoring at night.
Yeah, or
He's
over
getting paid.
yeah. I have friends who do that. Literally, will go on a hike or something and say, "I have to keep my laptop in my car just in case I have to run back." And yeah.
Yeah, and so that's a problem I'm having right here in terms of feeling comfortable about this. There has to be a little bit more clarification, more protection for the beneficiary, their home. That's an issue for me.
Yeah, the lengths of the compulsory nature of the site visit program are going to be interesting. Uh, you're not answering my question exactly as I want it. You're not giving me the answer that I want and thereby you're not complying. Oh God, Sam, that's what the RFE is going to read. That's what the noirs are going to read like, because I've read their noirs. Because you know what, I'm going to get on board with this, Sam. The most dishonest writing I've ever had from USCIS has been in the kind of post-site visit scenario. It's either head in the sand. We went to the site visit. We found the stupidest person at the entire work site, and they said, "Well, I never heard of that person," and we chose to make no follow up whatsoever, and thereby we're revoking your H-1B. And again, they're going to draw all sorts of conclusions from everything. Great opportunities for new lawyering, I guess.
Notice of intent to revoke on-site visitation is going to increase. There's no question.
Yeah.
And you and I have had we're professionals. We handle this for a living. We have great success with these overcoming these notices. Of course, clients have to pay us money to do them, but we've had nasty ones that we have overcome.
Historically, we have addressed some wacky ones for sure. And again, I am excited for the opportunity to do more lawyering on these things, because usually it's go away, attorney. I don't. If they do like typewritten site visits, site visit emails, for example, they'll accept an attorney response. But I never get the opportunity to be, pretty rarely anyway, directly involved in the H-1B on site where the employee is saying, "What?" What I like, Sam, is the idea of those employees can hire their own counsel for those sort of things. I guess they have to be able to, right?
Well, now it's getting to the point. Especially some of these aggressive, nasty guys. Now, good luck dealing with them. Before we used to say, we're complying. We don't have to comply.
Yeah, we're being
now he can cause some damage.
Yeah, you're not giving me what I want. Non-compliance.
And I don't know what complying means. Meeting or providing. Compliance. So how is that defined? We'll have to carefully look at that.
Yeah.
And this is 147 page, I think.
Yeah.
For the
here it is. Here's the official copy from the Federal Register. I call that about 140. Yeah, sounds about right. Yeah.
And we just scratched the surface of the surface.
Yeah. So we're thinking, to sort of wrap it up, Sam. We're talking about what we think is interesting right now. The fun part of new regulations is that the interesting parts, what the government takes and runs with. It hasn't manifests yet. I guarantee there's going to be at least some surprising thing in here that makes us miserable in the future. That that is just going to be surprising. Yeah.
So let's go ahead and start taking questions. We have a quick announcement usually when we begin taking questions. Just sharing with you that we don't know enough about your case to give you a complete comprehensive legal advice. We only have 5 or 10 words, and we try to answer the question in a more than one way. If you feel that you got something that got your attention that's really important, contact an attorney of your choice. There's a lot of good lawyers out there. A lot of people do contact us. A lot of people contact other lawyers. We're happy that you at least listened to us and found something of nature. So don't assume there's an attorney-client relationship established. because we're answering a question that was posed on the YouTube. So with that, let's go ahead and take those questions.
Okie dokes. Well, first one on the list. Oops, brought it up. It went away. Here we are. From MG. As of November 3rd, 24, rest of world EB1, 21,000, geez, pending, 28K run rate. EB1 India, available 4,030 until final action date, 4,069 pending until July 22, and then India progress given. Does EB1 India progress given these numbers?
Brian,
So,
you looked into these numbers for us?
what's it, me? So as of November 3rd, 2024, does rest of world EB1 pending, 21,007 pending, 28K? Does 28K run rate mean available? I'm having trouble. I'm having trouble following.
So EB1 21,007 pending in the pipeline,
Yeah.
Brian.
Yeah.
And if you recall, it's 28% of 140,000.
Okay.
Is the available.
Yeah. I lost my
right?
calculator, but yeah.
I do.
140,123.
And that's 40,000.
Mm-hmm.
So that's 30. That's 40,000.
39,200. Yeah. Yeah.
Okay. Of course, you have to subtract. So that's for the rest of the world.
Yeah.
So you have to subtract India and China. Each one is 2,744. So, which is basically 3,900. 39,000 minus 2,700 minus 2,700. That's 33,600. So there's 33,600 a year. But as of November 3rd, there was 21,000 in the pipeline. Okay. So that gives you about 10 or 12,000 float potentially.
Okay.
That's available for the year. Of course, this is not taken as of October 1st, which is the beginning of the fiscal year. Mm-hmm. So there is slightly less because they've eaten up some. So I'm going to have to say it appears to me that there's about 10,000. So that's when you start playing with the numbers, and that's when you start making the mistakes, because when you tell you rest of the world EB1 is 21,000 available, Brian, mm-hmm. You really got to multiply that by at least of 2, because when they adjust, your status.
Yeah, I see. But the backlog of
So that tells me right
is,
there,
a spouse and then usually a half a kid per. Yeah.
So that tells me right there, there's not enough to pass on to India or China of any significance.
Well, yeah, I mean, so I'm glad you were able to pick that apart, Sam, because I will admit that I was unable to, and that's why there's two of us here.
Oh, no problem.
Now, I guess what I have to say is I'm going to have to take the high level version. Visa availability is at its normal. 140,000 or 150,000 apparently is the final number available for employment-based categories the coming fiscal year, and I don't expect big movement anymore. This is not the times for the last 2020, 2021. Those were unprecedented times due to the impact of COVID. That is not the norm. I expect us to be pre-COVID of hey, look, we have our office meeting. How far did the visa bulletin move? It moved 1 week. Congratulations, we have one new I-485 employment-based for the India backlog to file this month in the EB2, for example.
Yeah, I don't see a movement in India of any significance given this number, in my opinion.
Yeah.
Simply because when they're looking at EB1 I-140s, unless these are filed concurrently and the number reflects with family, because when EB1 is current, you're allowed to file the I-140 and the I-485 at the same time. Yeah. So if that number here, 21,000, represent adjustments and family members, I'd say there's some float to pass on. But if this number represents I-140s only, no, it doesn't.
I guess, well, probably should move on, but I mean, I guess in the bigger picture, I say, big movement. I don't know, but I mean, EB1 India is the best place you can be, for India. There's whatever's not used by the rest of the world goes there. Even if you won't see big movement, you'll know that all the extra EB1 visas are going to the India backlog until it matches up with China.
Yeah.
And that's all you can really sort of, maybe not fast, but as fast as it can go, it's going to you.
Yeah.
Yeah.
In other words, how they look at the numbers, who knows?
Yeah.
Yeah. All right, let's take the next one.
So, Aniruddha, scenario: I-140 approved for 300 days. I-45 is pending for 120 days. I-140 revoked by employer. What will happen to my I-485? Can I wait 60 more days to use AC-21? My priority date is not current.
Well, that's an excellent question.
Yeah.
That's an excellent question. But no, because the I-140 was withdrawn, which supports the I-485.
Yeah. Within 180 days, yeah.
In less than 120 days. Just 180 days.
Yeah. It's not the answer I want. It's the answer I have to agree with. And even if they don't catch it, which they probably should, right? You still have a really kind of fundamental problem with the I-485, because that's it. If the I-140 is revoked before you hit 180 days, they're not supposed to be able to. There's no portability, and your basis for the I-485 is toast. Yeah.
I'm just surprised how in the hell this employer revoked this I-140.
Layoffs,
It could be future opportunity, though. When employers go through layoffs, Brian,
they usually don't.
They don't withdraw I-140s. They don't have time for it.
Well, the running joke is the immigration lawyer is always the last, at least for me anyways, is the last to know anything. And it's, that's it. It's usually employers. You're right. Employers forget to withdraw I-140 petitions.
They don't care about it. This is not something that's on the, they're withdrawing, they're running around with their benefits and money. They have all kind of scenarios and logistics and embarrassment and frustration and all. The last thing they do is run around and withdraw I-140. So for this employer to just run and withdraw an I-140, that's a mean thing to do.
Yeah. I guess is it not their obligation, though?
But if there is a potential future opportunity.
Yeah. Oh yeah. I've counseled employers to that. Hey, this person's leaving us. Do we have to? Should we should we withdraw their I-140? Well, the answer is, do you want to bring them back in the future? Do you have any opportunity for them if you're in that sort of business where you still like them, that sort of thing? That's why a lot of employers will not. Yeah. Well, here's actually a little bit of follow up here from previous question. Will it be safe for me to port jobs after I-45 pending for 180 days when my I-140 being revoked? Yeah, I think we've kind of answered that. Basically, likely they will come for the I-485 with a probably notice of intent to revoke that asks, do you have another basis for it?
So this one is a little different.
Oh, all right.
From a previous question, will it be safe for me to port jobs after the I-45 has been pending for 180 days?
But
will my I-40 being revoked prior to 180 days matter? Okay, same question.
Yeah. It basically, can I wait out the 60 days? And the answer is no, you can't. And even if they don't catch it within 60 days, you still have a problem with your I-485.
You're vulnerable. Yeah, you have a big vulnerability there because you do not want to go down the path of a green card that 8 years later they tell you sorry.
Yeah. Raise your hand.
Now here's what you can do. You can port and let them interpret it. You can fight the interpretation, and that buys you time because if you're getting EAD with the I-485, with the understanding that may be triggered today, may be triggered a year from now, they may not be looking at it. They not be connecting the dots. But meanwhile, if you have a pending I-485, Brian's shaking his head. He doesn't like what I'm saying. If you have a pending I-485 and a valid EAD, right now you can work. But what you can do is you can get to a new employer, file a new labor certification, file a new I-140, file an I-485, hoping that by then the USCIS has not gotten into your
I
but
will.
but no others, or get back on H-1B.
Yeah. Well, if you're presuming you're not on H-1B, I accept the premise that I-485 is still pending and the EAD is still valid as long as they haven't gone after it yet. But it's basically it's not nothing you can count on. I guess is
There's no foundation to it.
yeah.
Yeah, all right, next one.
So from Tech Topics, I-539 for change of status to F1. Payment has been charged from my credit card, but it did not receive receipt notice. How can I get notice duplicate copy from USCIS? Well, so one, call USCIS. If you call them, you may be able to get a receipt number. I've done it before on behalf of clients. If you have an A number, usually they can look you up by A number, even if you don't have the receipt number. And
I would be interested to know how long, because we've seen receipt notices come back 2 months later.
Yeah, it's rough right now. Yeah, for sure.
So if it has been like 3 weeks, 4 weeks, there's still hope.
Yep.
And you haven't changed your address.
No.
Those are and then they'll make sure that your address is correct on the forms. So those are the things that you should keep in mind.
So RK has some specific questions regarding the new H-1B regulations. What would be the impact of the bona fide job offer on the industry? So this is basically the requirement that allows them to ask for contracts in the new rules, and the same thing with third-party placement. For me, it's taking just a trip back in time, maybe not before June of 2020 when the IT Serve memo came out, but maybe like prior Donald Trump administration, where it's basically getting it back to where it was late Obama times when, yeah, you're going to require vendor and client letters for a successful case. But if you have those, fingers crossed, hopefully a high degree of certainty that the case will be approved.
What about the bona fide requirement of the degree?
Oh, the degree requirement, or you mean from the client or from the?
Yeah.
So there's a little bit. That's an interesting read. It's basically they're going to want to hear from the client, and well, raise your hand if your H-1B standard vendor and client letter has a degree requirement in it. They've always wanted to hear about it from the requirement. They've always said the client's true requirement is what is matter. That came from case law, but now it's codified. Which goes with the theme of a lot of this regulation is a codification of things we already knew. That they prefer to hear from the end client as to their requirements if they're the ones actually receiving services.
Well, yeah, I mean, we can talk about that more, but I think it makes it difficult.
Yeah, it more difficult than it is right now, because now it's a very permissive H-1B
because that may get you into short-term H-1Bs. Because of the bona fide, it comes in with a clause that says this contract is valid for 1 year. However, we can revoke this contract by give you a 90-day notice, or 15 days notice at any given time, or sometimes they refuse to give you a updated master service agreement. They give you a letter say, well, or verbally, you can work on the master service agreement from last year. Because under contract law, Brian, as you very well know,
I'm a lawyer.
Yeah, it's the conduct of the parties, right?
Yeah.
It's the conduct of the parties that governs, okay, and to modify sometime the contract, etc.
Yeah.
So, and USCIS is going to be looking for a rigid contract, and especially if you're going into a third party or a vendor and you're remote from the client who's not interested in giving exactly the documentation you need, it becomes difficult.
It's going to be interesting to see how that plays out, because I'm trying to think back to like the IT Serve settlement and like the court case associated with it, and for some reason I'm left in my head thinking that a judge said no, you don't get to approve for less than what is requested. That might be built into the law. Maybe I don't know. We'll see. We'll see how it goes.
Yeah, but that's interpretation of what was there before. What's there now is new regulations.
Yeah. Maybe that changes with the regulations for sure. So more from RK. The fiscal year 2025 EB green card limit is 150K according to the US for this year. Do you think the extra numbers already considered in the visa bulletin dates? Fiscal year 2025 EB green card annual limit is 150K according to the US for the year. Okay, yeah. Well, bottom line, apparently we have a number now. 150,000 employment based.
10,000 more.
Yeah, 10,000 more. I would not want the task. I don't think it's really hard to calculate whether that's impactful, and I don't know whether or not we'll know. Basically, I guess the fundamental question that RK is asking is, how long have they known that? Have they just got to figure that out now? Meaning that they'll be a little bit more
Or
generous.
is that built into? Is that going to help us going forward, or is that built into the
Yeah.
numbers already?
Yeah.
10,000 is a decent number. It's a
It's a-
8% jump, 7% jump, or whatever.
Yeah.
More green cards. That's a lot of green cards to hand out in fiscal year.
Yeah.
Beyond the 140,000. So,
Yeah.
but how long do they know? I haven't seen a noticeable jump in these numbers, and this information could not have been available more than 2.5 months ago.
Yeah. Yep.
And I haven't seen a big jump in the last 2.5 months.
Yeah.
There'll be a little
Again,
bit of a movement last time.
But
It
I
could
don't.
be.
I don't expect it. I don't expect it to be. I didn't expect it to be impactful, regardless. I wouldn't expect to. I wouldn't perceive. I don't think I could perceive an additional 10,000 visas more or less in the visa bulletin. Is my take on it. Yeah.
So you think it is inconsequential? It's a drop in the bucket.
For the 10,000 people out there who are going to get green cards faster than they might have been, it's not inconsequential. But in terms of, I think it's very, very unlikely that we would ever be able to ascertain where that number impacts the visa bulletin. Again, it's small movements. It's not massive movements like we had when it was double, triple.
It should impact a little bit.
What's that?
Yeah, I would hope.
It should. There will be more people will get green cards. It's just that I don't expect to. Oh yeah, that bump right there in the visa bulletin is 10,000. You spread those out across all the categories. It's relatively minimal, I would say. So from Empire, unlike the H-1B where there's a cap for new visa, the H-2A is an uncapped. Why do we have so many undocumented workers in agriculture section? Is that the employers don't want to pay the prevailing wage, or is the government doing something wrong?
So that's an excellent question.
Yeah, that's a great question.
Yeah, it's a great question. So the H2A is unlimited agricultural worker, but you got a problem. The problem you have is called the unlawful presence. So there's a law called unlawful presence, meaning that if you were here illegally in the U.S. and you leave the U.S., as a penalty, you cannot come back for 10 years.
Yeah.
Or 3 years,
Depending on how long. Yeah.
So all these agricultural workers today in the U.S. who have been working the farms for years, and the family's been working the farms for years, who have been illegal, that do not use the H2A. Do not use the H2A because they cannot come back.
Yeah.
That's number one. Number two, good luck finding good workers who's going to only come in, disappear on you, the cyclical nature and etc.
Yeah.
But I'm not an H2A expert.
Yeah.
But that's really the best answer I can give you.
Well, I mean, I'll give you a very simple economic one. So I could pay additional fees and do additional work to hire somebody, or I could not do that and I could hire somebody. And if the government's not enforcing the rules against me, why should I bother complying with them? I guess it would be my summary of it all. Save the cost, save myself the money. The risk of hiring them is low. The reward is any reward at all. If it's another $10,000 in my pocket a year, I'd like $10,000 in my pocket a year. There you go. So, yeah. So, can potential changes to birthright rules apply retrospectively for those, i.e., for those born before January 20th, assuming executive order is issued on that day? So, birthright, for me, I guess birthright is a constitutional question, Sam. It's the subject to the jurisdiction of the United States. It's the diplomat exception. That's where everybody believes is that they'll try to argue is that no. If you're here illegally, you're not subject to the jurisdiction of the United States, right? Or I think it's the phrase they use in the Constitution, subject to the jurisdiction, right? And an executive order on that day, retroactive, no. Retroactive, no, right? How can you? It just seems incredibly unlikely. Sam, I'm talking
Well,
here, so give me words back.
well, think about it from a practical standpoint.
Yeah.
You have people who were born here in the United States and were giving a naturalization
Yep.
document.
Yep.
And these people came here and moved into the US and built their life based on a government document that was given to them. These people married here and bought properties and opened businesses and had children who were born here. And these children also were born and got older and get married. I mean, I'm going to go back 100 years.
Mm.
How far can you go? And what is the legal process to remove someone who is given a document in the US? And what's the consequences of their children being impacted if they're born?
I mean, there's literal
Yeah.
treaties against this too. Creating stateless individuals. Are we going to take away somebody's United States citizenship, and what are they going to be? Are they going to be a citizen of Mexico, Honduras?
There is an impracticability to
Yeah,
them,
yeah,
a big one from a practical standpoint. Now, also from a legal standpoint, there is you cannot take citizenship from someone unless you go through a legal process.
yeah.
You have to go in front of a judge, and the judge have to say, "You're right. You don't get that." Okay. Now, stand in line and create this massive legal system. And if it can be removed easily by a president, the next president can reenact it equally as easy.
Touche. Yeah.
And I'm sure there is very deep constitutional questions. Half of them are answered. And if you talk about certain politics, people, they're going to say absolutely it's unconstitutional. You can talk to other people and say absolutely constitutional. It's going to go out to the U.S. Supreme Court. It's going to be decided. So good luck for the next decade to sort this thing out, and how much time is wasted, and what's the impact.
Yeah.
We got 10 million undocumented in this country. We cannot remove. Now we're going to go after another 10 million that we want to also remove.
Let's multiply our problems.
That
Let's spread our
requires
resources
even more
there. Yeah.
complex legal challenge.
Yeah.
The idea is stupid, but it puts fear in a lot of people's heart. And this is the horrible thing about irresponsible, big mouth presidents who talk, and open their mouth and disrupt people's life. It's not practical. It cannot be done. It will not be done. It is not an issue that anybody should be considered of.
Okay, cool. So I'm switching to F1. Can my wife do a master's on F2? Yeah, she's allowed to pursue her own education in the United States while you're on F1 status. But that's sort of that. Any other thoughts on that, Sam? Doing a master's on F2?
No, I think I agree with you.
Yeah. So, all right, I'll keep it going here. Well, we have another one from Tech Topics here. I'll maybe address right quick. What is the best way to reach out to your office? I dropped multiple emails, but no response. I was looking to file a U visa. So, depends upon where the email gets dropped to. If you're going to our website, there's a immigrationvisaattorney.com or shehabburke.com. There should be a contact address. Now, Sam, what are your thoughts on us and U visas?
Well, everybody is entitled to have an honest evaluation of their case.
Yeah.
A U visa is one of these things that is incredibly backlogged and requires documentation, and there's a lot of charged emotions involved in it. Every case stands on its own. Everybody has a right to seek counsel. Yeah. We will take some cases. We will not take other cases based on our conviction, whether or not the case is right for us as a law firm.
Yeah.
And whether the case we can deliver a service.
Yeah.
And we're human too. We are not perfect. If we feel that we can provide a benefit, we will do it. If we don't feel that we can provide a benefit, we won't do it.
No.
Very simple.
So, Oh, here's a great question from Wesley Sundar Singh, and it's going to create lots of good pilot and airplane metaphors because it's about the pilot program about visa extensions in the United States. Now, for me, Sam, if this we're using a pilot metaphor, that program was a pilot. This airplane is lost in the Bermuda Triangle, and we're never seeing it again. Because my one of my we talked a lot about that program maybe what is it a year ago when it was launched beginning of 2023 I think it was maybe a
Uh-huh.
little bit a year and a half
Uh-huh.
and it's a pilot. My running joke was it's going to be a pilot program. They're going to give visa stamping to one guy and pat themselves on the back and call it the end. Do you think that program's going anywhere, Sam? Do you think it's getting expanded? Do you think it's coming back?
Oh yeah, President Trump is going to love
Visa,
adding that one. Yeah.
yeah. um,
Yeah.
I think that I think that that the incoming administration. I've been doing a lot of research, Sam, lately regarding the concept of consular non-reviewability, the infinite authority of the consulates to make decisions and not get checked by the courts on it, and not and well, that's kind of it. And I guess I kind of have to agree with you. I think that that the incoming administration is very much likely to like the system where traveling is a gamble because you don't know whether you're going to come back because the whim of a consular officer can determine whether or not you get to come back. Short answer. Yeah.
I want to add on the birthright retroactivity
Yeah.
is very funny because what country is he going to belong to?
That's what I was saying. It's there's treaties we're signed on to that prevent us from creating stateless individuals.
Yeah.
Uh,
So okay. So you're not a citizen, but you can stay here. Oh, what good did that do?
yeah.
Yeah. And also, I think there was people are afraid. They go online and they search and they think, and there's a lot of people writing that it can be done. Uh, Nonsense.
Well, I mean, so if you're gonna think, I have my thoughts as to whether it can be done, and I'll be very succinct with them. So there's a line that says in the Constitution, I think it's one of the amendments, it says, basically people who are born subject to the jurisdiction of the United States.
14th Amendment.
14th Amendment. There you go. People who are born subject in the United States and subject to its jurisdiction are United States citizens. And the one exception to that is basically that we're aware of, that I can think off the top of my head anyway, is diplomats. If you're the child of a diplomat born in the United States, you are not a citizen because you are diplomatically immune. You are not subject to the laws of the United States. And so to say that basically people who are unlawfully present aren't subject to the laws of the United States, does that mean they have diplomatic immunity then? It just doesn't line
I
up.
think there is a Supreme Court decision, I think in the 1800s,
Yeah.
that ruled that if you're born here, you are a U.S. citizen.
Yeah.
Okay, so let this Supreme Court, then it has to go to the U.S. Supreme Court first.
Yeah.
And then let this Supreme Court overrule, what is a 200-year-old precedent.
They're going to love fighting with their desire to agree with the president versus their love of a stare decisis, right? Their love of old time versions of the law.
Yeah.
And they can go back to historical times. It's if you were born in the United States,
And then,
you were
and
a
then
United
the
States
other
citizen.
activity is like, okay, you're not a citizen of the United States. Okay, thank you. What country am I a citizen of? We don't know.
Retroactivity would baffle the courts, and just the burden of it all on everybody would be ridiculous.
The only way you can do it is to pass a constitutional amendment, and you would have to have 2/3 of Congress, which you cannot get 50% of Congress to agree on anything, but you need 2/3 of Congress, and then you have to provide reasonable notice, and probably forward. So the chances of that happening is about slim to none, in my opinion. But I'd like to sit back and watch it and see what happens.
I don't want to sit and watch it.
What you can do about it, Brian,
Yeah.
except sit back and watch. You can talk about
If
it.
the car's crashing in front of me, I don't. If I'm not running out to see it, I may as well not bother turning my head away from it. Sure. Sorry, if the plane is crashing in front of me, from Kumar Amit.
Prior to 2016, EB to India, my wife and myself didn't have a birth certificate. We obtained that last year from government office. Do we still need letters from relatives validating our date of birth? Yes, you do. The only birth certificate that is considered of enough credibility to not require secondary evidence is the ones that can attest to your birth around the time you were born. Documents issued, this is across all of any country.
Yeah.
Document issued not at the time of the actual birth and within a week or 10 days of which require secondary evidence.
Yeah. Yeah. I would say it's possible to check the birth certificate. If your birth was registered, but you just didn't have the certificate, getting a new birth certificate that bears that original registration date, close to your birth is a
Yeah.
possibility. That
Yeah.
sometimes happens.
Yes.
Yeah. So from AK, will the revocation of my I-140 matter?
Will the revocation of my I-140 matter after porting my job once I-45 has been pending for 180 days?
The same person with the same question there, and it's basically
So we have these charts, guys. We have on our website a chart that lays it out. Every scenario like this, I think it's Brian. If you can find it and put it there in a note for everybody to look at. So there is that, and also there are 3 YouTube sessions that we did that broke down every potential scenario. And what was the title for those YouTube, Brian? You remember?
I think it was change of employer with green card in process. I think we have them turned into a playlist, as I recall.
Change of employer with a green card in process.
Yeah.
So you can type that and type YouTube Shihab Burke or etc. You could find us and you can watch it. So, but to answer your question, if the I-140 was withdrawn after the 180 days, now you only need to provide a supplement J for a new employer to show that you have changed your job to same or similar job classification, and you continue with your green card application.
Yeah, but
And
again,
that's the magic of the 180 days.
Yeah, but if you didn't make it past 180 days, if your I-140 was revoked before then, you're gonna have you can expect a problem with your I-45.
Yes.
Yeah. So let me see here. Before I filed F1 COS for masters, I also filed compelling circumstances. It's received RFE. Can I start masters while compelling circumstances EAD is pending? Whew. So there's so many unknowns here.
The answer to that question lies with your DSO, designated school official.
Yeah.
Whether he can allow you to begin studies if the change of status was filed, I'm assuming prior to the begin date of the program on your I-20, and whether he's comfortable allowing you to begin studying. Really, he's the one or she's the one that's going to answer that question for you, in my opinion.
Yeah. I mean, for most visa classes allow you to go to school in the United States, and meaning if you're in an H-1B visa, it's a visa class that allows you to work to go to school in the United States while engaging in the primary activity. You may be able to attend school while the F1 change of status is pending, but for example, visitor visa doesn't allow you to attend school.
But the interesting one for me, Brian, that Tech Topics hasn't asked, or maybe he asked on the next question. Let's assume I have moved and start studying for 3 months on F1, attended school, and then my compelling circumstances EAD was approved.
Yeah.
What do I do?
Well, you decide whether you want to be a student or whether you want to be a compelling circumstances EAD user without status,
So he can jump on the EAD and work and stop studying.
Yeah.
Or he can continue studying and ignore it.
But lose your F1s.
But not both.
Yeah.
So you get to choose one more time.
Sam, you think that compelling circumstances EAD, those generous policies relating to them, are going to remain with the incoming administration? The ones that say, if you have a house, a couple kids in the United States, we will see, I guess, right?
Yeah.
Well, speaking of the hypothetical, what's going to happen during the incoming administration from Wesley, will the Trump administration bring back the credit report, bank statement, and public charge rule as a part of adjustment of status? I submitted reams of papers while filing I-485.
You submitted one, we submitted thousands.
Yeah,
We were buried with papers.
Yes, many thousands, at least hundreds of reams of paper burnt up on documents that ultimately went into the garbage can at USCIS. Really painful to do.
Yeah. Yeah. But how do we know?
Yeah.
Fine. Approaching 7 o'clock. Let's take last one.
Yeah. Let me see here. So MG is, I'm going to maybe figure out what MG is saying here. MG was talking about the statistics, saying, doesn't pending I-45 report imply all 45 submitted, or does it only include I-45s for the dependent? So that's a great question about those reports, I guess. And it's so I think it basically goes to the fact you were saying
it's going to have to be all family members, because if the principal beneficiary's I-45 is approved,
yeah,
then the family member has to do a following to join, cannot file I-45s.
Yeah.
So the 45 report has to assume all. And if you're giving me the 20,000 that was an I-485 report, so that leaves few thousands of potential EB one to flow to EB1 India first and then China. But the fact that the visa bulletin is not moving forward for India does not mean that these are not being used up by India, because you have the offsetting EB2 with all the priority date that are moving to EB1 and able to take one of these numbers. So if that answers the question.
Well, I'm going to make this next one our true last question here, because I think it's a really, really great one, which this is going to have a fun answer. A good one. From Bona. Can the 90-day rule be waived for H-4 visa holder if they want to apply for I-485? And I would say, what are they likely referring to, Sam? I would say they're likely referring to the quote-unquote 90-day rule that says you should not do something inconsistent with your non-immigrant visa within 90 days of entering the United States, like applying for a green card. It's a common consideration, for somebody who's entered the United States on a visitor visa. Can I get married to a U.S. citizen and apply for a green card? And I'd say, well, you might want to think about that, because that might look like immigration fraud to you, like you use your visa, your visitor visa that requires you to return home for the wrong purpose. But what do you say about this, Sam, when the visa is an H-4 visa?
Well, there's something called dual intent.
Yeah.
And with dual intent, when you enter the U.S., the 90-day rule not only deals with dual intent, deals with representations made or assumed to have been made at the time of entry to the U.S. And really has to do with also having a foreign residence for which you intend to return, more so than the dual intent.
Yeah.
So with a B visa, for example, you are promising the government that you have a foreign residence that you intend to return to at the conclusion of your B visa. That's assumed in the law, whereas an H-4 does not have that requirement.
Yeah.
And therefore, that's why you don't have to put a foreign residence on an H-4 or H-1B application when you file it. But no, don't worry about the 90-day rule for H-4 and 2485.
Yeah, you could literally walk into the consulate, apply for an H-4 visa, say, I'm applying for an H-4, and also after I get there, I'm going to file for I-485, and they shouldn't have any problem with that, because H-4s allow immigrant intent. So
with that, we conclude today's presentation. It's 7:04. Until next Monday, 6 o'clock Eastern Time, please have a fantastic rest of the week.